Welcome. Welcome to today's Institute of Judicial Administration program. My name is Alan Klinger, graduate of NYU Law School, a member of the Law School Board of Trustees and the Labor and Employment Center Advisory Board. And on behalf of our fearless leader, Professor Sam Estreicher, who is in Europe on a deserved sabbatical, we welcome you here today for the program. For those new to IJA, it is a nonpartisan, nonprofit institute whose mission is to improve the administration of justice. And it serves as a forum for judges, academics, and lawyers to discuss legal developments, institutional issues in a non-ideological way. That's always been a very important part of the IJA. It provides training for judges, including for new appellate judges, where I believe that today's participants were part of the program. And one of them, as you will hear briefly, has taught at it for a long time. The IJA also hosts conferences such as this in order to explore current legal developments. Before introducing our esteemed panel, just a bit of historical perspective. I started NYU Law School in 1978, which was shortly after the publication of Justice Brennan's seminal article in the Harvard Law Review on state court constitutions and the protections of individual rights. This was a big topic during the years here in the constitutional law classes. And I think it's very interesting that now, almost 50 years later, we're here today to discuss assessing the rise of independent state constitutionalism. And with this, for that, brief introduction of the panel, further explanations in the material, starting first with Judge Dan Friedman of the Appellate Court of Maryland. Judge Friedman was appointed to the court in 2014. Prior to that, Judge Friedman was counsel to the Maryland George Assembly in the Office of the Attorney General. He was in private practice before that. He is the source on issues of Maryland constitutional law, on the state constitution. He's written reference guides about it. He also teaches at the University of Maryland Law School. Our second panelist is Judge Lisa Lorish of the Virginia Court of Appeals. Judge Lorish has served on that court since 2021. Prior to that, she worked as an assistant federal public defender and the appellate specialist for the Western District of Virginia, representing a wide range of defendants. Prior to that, the judge was a litigator with Sullivan and Cromwell and McGuire Woods. And she too attended the University of Virginia School of Law and is an adjunct there. And the presiding judge for the panel is Judge Sutton of the U.S. Court of Appeals for the Sixth Circuit. He is the chief judge there. He has served as chair of the Federal Judicial Conference Committee on Rules of Practice and Procedure, chair of the Advisory Committee on Appellate Rules, and chair of the Supreme Court Fellows Commission. He currently serves as chair of the Executive Committee of the Judicial Conference of the United States. He has long been an adjunct professor at the Ohio State University College of Law, as well as teaching a class on state constitutional law at Harvard Law School. He is also the author of Who Decides? It has a very long title, but trust me, you get the point of it in terms of the title of Who Decides. And he's co-author of a casebook on state constitutional law. Judge Sutton also is a regular faculty member of the IJA'S New Appellate Judges Seminar. And with that, we have today's program.
All right. Thank you so much. Thank you to NYU, to IJA, to Alison Shafini for organizing this. The three of us are thrilled to be here. This is a great place to do a discussion. So one kind of rule to start is at any point, if we're saying something that triggers a thought, question, don't hesitate to raise your hand. We are going to leave some time at the end for questions, but, you know, this is a nice intimate environment, so don't hesitate to raise your hand if there's something you want us to address as we're speaking. I'm going to get things started by talking about three basic topics. One, why now? Why are state constitutional and state courts so much in the news? A second topic will be kind of how to maximize the use of state courts and state constitutions in protecting your clients. And the third is to pull back the lens and kind of talk about how the federal and state systems work together. After all, I'm a federal judge, so I'll talk a little bit about that. Then Dan's going to offer a few thoughts about his experience in Maryland, and then Lisa the same in Virginia. And at a minimum, give you time for questions after that. But again, you can interrupt us throughout. I'm going to start where the 1977 Brennan article. So that's kind of a signal event. It's one of the most widely read, I think it's a top 10 article in terms of readership. And so Justice Brennan, of course, at the time was on the U.S. Supreme Court. By 1977, the Warren Court was no longer. It was the Burger Court, soon to be the Rehnquist Court, and a court that was not innovating rights in the same way the Warren Court had. And Brennan's article was basically a call to arms for state court judges to use their state constitutions to protect rights that the U.S. Supreme Court was not protecting as aggressively as it once had been. The article does make a big difference. I will say it's really not earth-shattering, and that we could go back to why it maybe didn't make as big an impact as it might have. I think one quick explanation might be that the article was perceived as speaking a language solely for progressives and not speaking a language that conservatives or more conservative originalist judges might embrace. So a more progressive state court judge would jump on the article and say, what a great idea, let's do this in New Jersey. But a more conservative judge in, say, Florida might say, well, if Bill Brennan likes it, maybe not so much. But let me tell you an article that's in that same 1977 volume of the Harvard Law Review, which to me, in some ways, is a little more interesting looking back on it. It's an NYU, at the time, NYU professor. He may still be teaching here, Bert Newborn. And he writes an article in the same volume, 1977, and it's called The Myth of Superiority. The Myth of Parity is his article. And what Newborn says is, at the time, I think he was general counsel for the ACLU, and he's really directly responding to the Brennan article. And he says, when it comes to my clients at the ACLU, whether they're criminal defendants, free speech advocates, federal court's the place to be. I would rather have a life-tenured federal judge. I'd rather invoke the federal Constitution than I would a state court and a state constitution. So that's his piece, again, called The Myth of Parity. It's 1977. 22 years later, a fellow named Bill Rubenstein, who's now a professor at Harvard, writes an article called The Myth of Superiority. So he's clearly responding 22 years later to the Newborn article. And what Rubenstein says is, I don't agree with this. Now, Rubenstein's experience for the prior decade and a half had been not as broad as ACLU. Most of his work had been in gay rights litigation, but still a very counter-majoritarian form of litigation in the 90s and 80s. And Rubenstein says, we did better in state court under state constitutions than we did in federal court under federal constitutions. And he proceeds to try to explain why that might be so. I think Rubenstein was onto something. It's quite dangerous to assume that federal judges are going to be more rights protective, even though they have life tenure. And here we had an advocate that saw this exact thing happen. That leads me to move forward from 1999 to today, where I think what's going on is nothing Rubenstein or Newborn or Brennan could have imagined. And a way to capture the present is to say, if you were to look at Wall Street Journal and New York Times articles, two national presses, one conservative, one liberal, and if you were to look at their articles over the last 7 years, you would find more articles about state courts and state constitutions than they have written in their prior 100-year-plus histories. Now, these are profit-making entities. They're trying to write articles that their readers want to read and pay subscriptions for. What's going on? I mean, it almost seems like Armageddon. What's wrong with us? People are reading about state courts and state constitutions. It's almost scary. Well, there's a kind of a simple short-term explanation and a broader explanation. The simple short-term explanation is the current U.S. Supreme Court and some very epic decisions by that court over the last 7 years. And the two that really deserve attention are Dobbs, the overruling of Roe, and Rucho, which I don't think is appreciated quite as much, but might actually be even more important in some ways. Rucho's the case where the U.S. Supreme Court said that the federal Constitution really has nothing to say when it comes to extreme partisan gerrymandering. So what's significant about those two cases, they both overrule prior U.S. Supreme Court decisions, Roe in one case, this case called Davis in the other. And it's the U.S. Supreme Court withdrawing from the field and leaving a very big vacuum over two very salient, politically salient issues in America today, abortion rights and gerrymandering. Well, if you pull the federal courts out of the mix, Congress is AWOL when it comes to gerrymandering. They could play a role, but they have not been able to yet. It's hard to imagine Congress entering the mix on abortion. So you really have a situation where it's states or nothing, and the American people are not tolerating nothing. So they've gotten very involved, whether amending state constitutions, state court decisions, state legislation. So I think that's one big explanation for why we're really suddenly paying attention to state courts and state constitutions in ways we hadn't before. A second one is that, most people didn't appreciate this option of going to state court and kind of getting a second bite at the apple, a second shot at a victory for a client. Really hasn't existed for most of American history. It's really the rights revolution with the Warren Court and incorporation of the Bill of Rights, the 14th Amendment, that gave state courts and federal courts the opportunity to limit state or local laws, state or local criminal prosecutions. And the third thing going on today, which is the one that excites me the most, although maybe it surprises you given that I'm a federal judge, the best lawyers in America are all becoming state court judges, which just warms my heart to no end. I've got two of them here. I have Caitlin Halligan here, Mike Garcia here from the New York Court of Appeals. I mean, truly, many of the best lawyers in America are going off to serve in state SG offices, working in state government, and then going on their state courts. And there's nothing that will kind of change our perceptions of state courts and the way state constitutions are interpreted than having terrific lawyers construing them. So those things are all very big developments. Second topic I wanted to mention at the outset. How is it that litigants, let's say they've got a client facing a state or local criminal prosecution, they obviously want the client not to have to go to jail, they know there's a Fourth Amendment, they know there's a Fifth Amendment, they know there's a cruel and unusual punishment clause. They also know today, happily, is that their state constitution has counterpart clauses, search and seizure, cruel or unusual punishment, self-incrimination clauses as well. How do you get state courts to independently look at those clauses and not lockstep with the federal courts? It's a really important topic because a second shot doesn't mean much if you don't get the state court to look independently at the state guarantee within New York, Ohio, Maryland, Virginia, whatever the state might be. And here are just a couple ideas, and happy to take questions later, but just a couple to make sure we get a few things on the table to start. Well, first of all, it's true that a lot of the state constitutional rights guarantees imitate the federal guarantee or have similar language, but not always. In fact, if you were to look at Article 1 of your state constitution, most Bill of Rights, declarations of rights in the state constitutions come first in Article 1, you'd see that often the language is different. Different words, different meaning. So that can be a very good reason to get an independent interpretation, break free from whatever it is the U.S. Supreme Court's doing with the counterpart clause. The second reason, if I had to put my finger on the best reason why state courts often chart their own paths is litigants who found something unique about that state's history, values, norms when it comes to whatever the topic is. I've never met a state judge, conservative, liberal, Democrat, Republican, originalist, living constitutionalist, that didn't have deep pride about their state's history. So it's just always something that gets state judges' attention, and that history can be, the first constitution in the state. It can be an historical incident. It could be a criminal prosecution that went awry. It can just be a range of things. But the key point is it's a very localized idea, and it's usually historical in some way, which that historical event reflects a value, something the people of that state have pride in. A third one, which is quite underappreciated, and it's one I'm embarrassed to say took me about 20 years to figure out. I mean, talk about a slow-thinking individual. But this one is really good. I'd say it applies about half the time. I think I can say this pretty safely on behalf of all appellate judges. We care deeply about methods of interpretation, and that's why you have these big debates about whether you're on the Scalia side, formalist, fixed meaning, very text-based, unchanging, or the Ginsburg side, less fixed meaning, more purpose-driven, sometimes capable of evolution, more informal. If I were to generalize somewhat grossly, but I have to say probably pretty accurately, if you were to look at all U.S. Supreme Court constitutional decisions, they're probably half and half. I think half the time you're going to find it looks a little more like the Scalia mode. The other half the time it's going to be more the Ginsburg mode. I've never done the math, but I'll bet you I'm in the ballpark. Why is that statistic quite important? Well, just as U.S. Supreme Court justices have prevailing methods of interpretation, the current U.S. Supreme Court errs, I would say, the majority on the Scalia side today. The state courts are the same. My state court, the Ohio Supreme Court's a little more in the Scalia mode. If I were to guess, the New York Court of Appeals is probably the majority, a little more the Ginsburg mode. New Jersey Supreme Court, clearly more the Ginsburg. They would prefer to say Brennan mode, since Brennan was from New Jersey. But the point is, all of these state courts have a majority approach at a given time. Why is that significant? Let's say you're on the New Jersey Supreme Court, and the counterpart federal interpretation is a Scalia opinion. It's not just that the New Jersey Supreme Court justices would be unlikely to follow a Scalia approach to interpreting, say, due process. They would actually think it's presumptively wrong by their lights. That's highly significant. In other words, in terms of the lockstepping problem, it's quite weird for someone who uses a different method of interpretation to lockstep with their opposite school of thought. And vice versa is true. If the Ohio Supreme Court, which leans in the Scalia method, has a Ginsburg precedent on the books, they're not likely going to follow it. In fact, they should think it's presumptively wrong.
Jeff, can I?
Yes,
go
for it.
So we recently had a decision in Maryland that I think is at least as common as the two schools that Judge Sutton is describing, where the Supreme Court precedent is very fractured. This is the admissibility of documents by experts and what the Confrontation Clause requirements are. And the Supreme Court has been a complete mess, and essentially Justice Thomas's single person concurrence is under the Marx rule the only thing. And my Supreme Court decided if it can't even persuade the rest of the Supreme Court, following that is not a reasonable interpretation. So that's sort of a complexification, I think.
Did the Maryland Supreme Court decision, was it more protective than Crawford on the Confrontation Clause?
More protective
of the individual, the defendant?
Yes.
Oh, good for you.
So
But that just shows how dangerous it is to draw too many assumptions about methods of interpretation, because Scalia wrote Crawford,
did.
and it's a very pro-criminal defendant decision. Sometimes originalists can lead to very protective things, but that's amazing. The Maryland Supreme Court went even further.
Yes.
Wow, you guys
So-
are outdoing Scalia on that one. I thought that was hard to do. That's good. No, that's a great example of the way these can interact. Which the last point I'll make, and boy, as a federal judge, I'm an expert on this. Don't assume the federal doctrine makes sense. If there's one thing about being a judge for 23 years, I'm skeptical of a lot of our things, like tiers of review. I mean, how many are we going to have? I think we have 7 at this point, or at least some people think we have 7, but at a minimum we have 4. If you're a state court judge or you have a case in state court where tiers of review don't help you, why in the world would you casually say state court use tiers of review for this equal protection like claim? So, in fact, I think one of the best things about being a state judge, I feel like my whole career has been an audition to become a state judge, is that you can reject the U.S. Supreme Court. I mean, how much fun is that? To say, well, you were just explaining that. We said we're not going to follow Justice Thomas. I'll bet they smiled when they did that. They thought, this is so much fun.
Another one, the Supreme Court unanimously decided Wren.
So this is the stoplight or pretextual stops point.
Exactly. And I think, I'm just an intermediate judge, but I think that's a wrong decision.
Hey, we're
and
all
it's
intermediate, and the word just is never used before. That is not adjective, adverb,
Well,
I'm not sure.
Somebody else will make the decision. But these Wren stops, it was a unanimous decision. Everybody signed up to it. And I think it's had very deleterious effects on police and on people driving. I think it's made our country less free and less safe at the same time. It's a remarkably bad interpretation, in my view. And so I have urged my Supreme Court, thus far unsuccessfully, to reconsider and think about a better answer, not a left or right answer, but a safer and freer answer.
Well, if I could just build off that one, because this is something we all understand, because I'm pretty confident most of us here drive. What the Wren court did, and it was a unanimous decision written by Scalia, is it said, if the police are following someone, and let's say they're following them with a purpose, like worst of all, profiling, but for whatever reason they're suspicious of this car, and they're following the car for good or bad reasons, if they notice the car violate a traffic law, which can be something as simple as slowly going through a stop sign, not doing a turn signal, going a mile over the speed limit. If they have an objectively provable evidence of a traffic stop violation, they can always stop the car, and it doesn't matter what their motive is. So even if they were, like, literally, what is this group of people of this race doing in our neighborhood, and they're following the car for that reason, if that car violates a traffic law, it doesn't matter why they stop the car. They get to stop it, get them out of the car, frisk them. So Dan's right. I'm not going to take sides on the issue, but what I am going to say is that is a very big deal when it comes to liberty. Like, if you think one feature of being an American is the liberty to go where you want without the police stopping you or doing it for pretextual reasons, he's quite right that decision diminishes liberty. It's a complicated decision. There's a reason all 9 signed up for it. But what's wonderful about state con law is that's just a threshold for the federal Constitution. It doesn't prohibit a single state from disagreeing with it and saying, in Maryland or Ohio or Virginia, we're going to do more. We should talk about Terry later. But I'll circle back to just my last couple points, and then I'll turn it over to Dan and then to Lisa. My last one is to pull back the lens. And if you're not excited about state con law yet, I hope this really seals the deal, because this, in my view, is the best part of it. what we have lost track of in America is how these two systems are supposed to work together. That it's American constitutional law, it's not federal or state constitutional law, and it's actually really exciting because it goes to the great question in American history. The great question in American history, which we're constantly debating over different topics from 1776 to today, is what problems deserve a national solution, what problems deserve a local solution. And when you think of American con law and you pull back the lens, what you realize is we have three types of stories, not just one. So one type of story is the nationalization story, where the federal Constitution covers the topic and a U.S. Supreme Court doing its job should nationalize the solution. So the best example of that is Jim Crow, the mistake of Plessy, finally corrected in Brown. So clearly, race discrimination, denying people benefits based solely on their race, was something that the Equal Protection Clause speaks to and something that should be nationalized. Now, states can still go beyond that protection, but the key point of that story is that's a nationalization story. The second type of story is what I'll call a cooperation story or Brandeis story. And that's where the state and federal courts work together on identifying new rights, new norms that ought to be reflected in the national Constitution, but aren't necessarily explicitly in the U.S. Constitution, or at least they're edge issues when it comes to interpretations. My two examples for that are the right to counsel story, Gideon. So when the court nationalizes a right to counsel and says anyone facing a felony prosecution, state or federal law, you can't move forward without giving them an attorney. That's a very big deal in this country. Gideon comes after decades of the state and federal courts trying to figure out how to do that, and the state courts using state constitutions as potential solutions. So what's neat about that story is it isn't like a lightning bolt out of nowhere. It's the state courts in the vanguard, the first responders to the problem, and then in Gideon, the U.S. Supreme Court nationalizing a right to counsel, but after quite a bit of experimentation. This is, of course, Brandeis's laboratory's point. A more modern example of this kind of cooperative identification of national rights would be the marriage story. Okay, so the marriage story starts in, I think it's 72, when the U.S. Supreme Court in a case called Baker says the 14th Amendment does not protect a right to same-sex marriage. That leaves only the option of going to the states. The states, it takes a while to get going, but starting in the 90s, they do start addressing the issue. And when Obergefell in 2015 nationalizes marriage equality, Justice Kennedy's opinion points out this dialogue, cooperation between the state and federal courts, state and federal constitutions before you nationalize. So that's story number two. Story number three is the most provocative point I'm going to make today. Sometimes, this really cuts against our civics education, sometimes the very, very best thing you can do for a right is not to nationalize it. Sometimes the people that can do the most protection are local communities for whatever reason. Now, these stories aren't always static, so the examples I'm going to give could change tomorrow, but at least today, you can make the argument that the very best way to protect these rights was locally through state constitutions. So school funding is an example of that. U.S. Supreme Court refused to nationalize it. 3/4 of the state courts entered the mix and did some pretty significant things. Kelo, the property rights case, very infamous decision. Conservatives in particular, very critical of this case that allowed the city of New London to seize Suzette Kelo's property, among others, in this middle-class neighborhood to create a headquarters for Pfizer. The headquarters is never created. These people still lose their homes. They get compensation. And the question was whether that was a public use. And U.S. Supreme Court said it was, because it was for the broader economic livelihood and economic benefits for the community. But it's a much lamented decision. What's fascinating is the state courts, state lawmakers, local government officials entered the fray, And all the people that want to try to overrule Kelo can't even find a test case. And what you've had is just lots of local experimentation. In fact, New York Court of Appeals has a really interesting case called Goldstein, which has its own permutations on this. So my point is there's three different stories about American con law. The nationalization story, think Brown. The cooperation dialogue story, think Gideon, Obergefell. And the localism. The very best thing you can do for the right is protect it locally, keep the national court out of it. It's either going to deny the right or it's going to dilute its protection. All right, so Dan, why don't you offer a few thoughts?
Well, so Jeff said
I knew I would provoke you on this.
Jeff said I might keep a pad so I could write down the things he says with which I would like to make comment, and I did.
Go for it.
So one of the things people say about state constitutionalism is that state constitutions aren't real constitutions. They don't look like the federal Constitution. And when they do that, when they make fun of your state constitution in New York, they make fun of the width of ski trails. And in my state, they make fun of off-street parking. There's a provision of the Maryland Constitution about off-street parking. But, and I sputter every time I get to this point, it's not really about off-street parking. Well, there was a parking crisis in Baltimore City, and the question was could the city condemn property to turn it over to a private developer like Pfizer in your Kelo story? And what that provision actually does is decide the Kelo case before Kelo comes up. In the 1970s, we said it is okay in our Constitution to take this property, hand it over to a private developer to encourage the building of off-street parking. So that's why people make fun of it. In New York, the width of ski trails, I understand, is part of the Forever Wild. It's an important environmental thing. So when people make fun of your state constitution, that's wrong. Yes. So, these constitutions aren't always written in the language of due process of law and fancy. Sometimes they're very mundane, and sometimes all it is it reflects the judgment of the people that we do not want this to be subject to the legislature. I litigated this in Maryland after we amended the state constitution to allow slot parlors or whatever they're, gambling in Maryland. And our Constitution now has provisions about where those 6 things can be in the state of Maryland. Is that too detailed for a Constitution? If you're comparing it to the U.S. Constitution, sure. But if you're saying we don't want this to be subject to the state legislature, that's a legitimate place to put it. What I think my portion of the program is to say each of the 50 states has its own story, and they are unique stories. They are different stories. They come from different places, and it's really interesting how each one is put together and how they work. My state, Maryland, wrote its first constitution in 1776 in the middle of the Revolutionary War when Judge Sutton used the verb imitate. It was, the fingernails on the chalkboard. My state didn't imitate the language of the United States Constitution. We drafted for it. We were the first draft of it. Our Declaration of Rights, which, by the way, was copied very clearly from Judge Lorish's.
Not me personally.
Wait. So you're acknowledging you did imitate.
We thoughtfully copied the Virginia Declaration
So
of Rights.
Plagiarism, just a different source.
Well,
okay.
so
All right.
if you want to read a brilliant article, it's in the Rutgers Law Journal. what I did is took the May 27th Virginia draft of the Declaration of Rights. Our guys looked at it. They saw the protections that criminal defendants got in Article 10 of that May 27th Virginia Declaration of Rights, and they said, that's pretty interesting, but the right of against self-incrimination, that shouldn't be in there because we want that available not just in the criminal context, but in the civil context. And so the Maryland framers said, let's move that out. And in Virginia's, it was only the right to due process was only in that Article 10. And the Maryland framers said, ooh, we might want that due process in other contexts other than in criminal context. So let's move that out and not limit it to the criminal context. It was copying, but it was thoughtful copying. Try that within my classes, right? So each constitution has, each state has its own story. Our Constitution, the first draft was written in 1776. We rewrote it in 1850 on the eve of the war. We rewrote it again in 1864 in the middle of the war. And in fact, if you read the constitutional proceedings, the debates and proceedings, they take a 3-week break because Early is coming up the Shenandoah and crossing into Maryland at Monocacy Junction and threatening their homes. So everybody suspended work on their Constitution and went to defend their homes because of because the war was at our doorstep in 1864. And then in 1867, just 3 years later, we had a third constitutional convention. And essentially, we were there, and the delegates were very clear that they were there to undo what had been done in 1864. So they wished they could undo emancipation, which was the largest part of the 1864 Constitution. They wished they explicitly, and that is the Constitution that remains in force in Maryland today. So sort of when people talk about originalism and they're looking longingly at James Madison and all those great founding fathers, our founding fathers who wrote the Maryland Constitution of 1867 were racist, reactionary people, and so I'm a little less excited to be an originalist when I'm looking at the Maryland Constitution. We had in the 1960s, as many states did, we had a constitutional convention to consider a new constitution, and the voters rejected it, although we've piecemeal adopted a lot of the good suggestions. So what we're living with is an 1867 Constitution, heavily amended, but written to repudiate lots of things that, all the progressive things that happened in the middle of the war. And what's most fascinating, I think, as I think of myself as an archaeologist, because there are provisions that that remain in the Constitution that have been there throughout. So I've been working on a piece where I was looking at provisions from the English Declaration of Rights of 1689 that got sucked directly into the Maryland Constitution of 1776. These, and I don't want to bore you about the Glorious Revolution, but that's my new hobby, so I could go a little bit on that, but it was really the victory of parliamentary supremacy over the monarchy, and many of the provisions of the Maryland Declaration of Rights celebrate that parliamentary supremacy, and they're still there when parliamentary supremacy has really our General Assembly's supremacy over the course of other provisions of our state constitution have declined. And the interpretive challenges are, what do you do with a provision about making the legislature supreme when read next to other provisions that are not supposed to reflect parliamentary supremacy? What I mean to suggest is each state constitution is different, has its own history, has its own remarkably interesting history. I make fun of the people who only do federal constitutional law because you only got to know two things. You got to know the 14th Amendment and you got to know the foundation. Big whoop. So
A little bit of simplification, but can I mention something? The archaeology thing reminds me of that Agatha Christie, the great state constitutionalist, was married to an archaeologist, and what she said about that is it's beautiful because the older I get, the more interested in me he becomes.
my parents both were archaeologists.
Ah, love at first sight.
I guess, in the dig. I want to jump topics again. Each state, many of our state constitutions have both rights sections and structural sections. And there is no court that has a hard time, no state Supreme Court that has a hard time understanding its responsibility at interpreting the structural provisions. And I was counsel to the General Assembly. That was the advice that I gave. How long does the governor have to wait after a presentment of a bill? What does presentment mean before he has to sign? Or we have a pocket passage in Maryland as opposed to a pocket veto. And so all those things, the state Supreme Court never says, oh, I'm really nervous about interpreting this. They know that that's their job. But my state, particularly, when it comes to the rights provision, freezes up a little bit and looks at it and says, I'm going to listen. I'm going to do whatever the Supreme Court of the United States does. This is that lockstepping idea. Let me be clear. I have no problem saying the Supreme Court of the United States has thought about it. They got the input from the courts of appeal. Lots of smart people are thinking about it. It's not just the two lawyers who are discussing it. But they do not have a monopoly on good ideas. And so we ought to reconsider it. If a rule is not working, if it isn't rights protective enough, if it isn't doing a good job, I think Wren, as I said, liberty is important. The case that Wren came up to my court in recently, there's a white line and a left turn lane. And because of the way the intersection is built, to get out of the way of the straight traffic line, the people who want to turn left cross the white line. And the police camp out there to watch for people crossing that white line. They're not, nobody suggested to the Department of Transportation move that white line back 100 feet so people could be legally turning. The cops will love it. They're camped out there, and they are not ticketing anybody for crossing that white line. They're looking for drivers of color. They're looking for people who look suspicious, and they are taking the opportunity to search cars. And that is not, it's not safe for drivers. It's not safe for police. This is the most dangerous interaction for police. I'm sorry, I'm getting excited.
Well, I'd never heard of the drawing the lines to make it easier to find a violation. That's really sketchy.
I'll bet they do it in Ohio,
Well, do they
too.
do it in Virginia? Maybe we should let Lisa say a few things.
Yeah, sure. Well, first, it's a real honor to be back in this particular room. I first had the privilege of coming up and getting to know a bit about IJA when I participated in the new appellate judge school about 4 or 5 summers ago. And it was really in this very room that I got to hear Judge Sutton speak about state constitutions and why state appellate judges, now finding myself among that group, should think differently about their state constitutions and not just assume that a provision of your state constitution should carry the same meaning that an analogous provision of the federal constitution might hold, the lockstepping concept you've heard come up a few times today. And I now have the privilege of getting to teach state constitutional law at UVA's law school and have written a bit about Virginia's constitution and what's happening, kind of newly happening in our state when it comes to state constitutional interpretation. So I thought I'd take a few minutes to try to be more practical. This is a former practitioner in me, I apologize. To think about what it looks like. We've heard mention every state constitution is different. That is a real bummer if you're a practitioner, because it's really hard to become an expert about 50 different state constitutions, all the amendments that are taking place, all the different decisions that are coming out. It's a lot easier to focus on federal law because it's the same everywhere. If you're an academic, it's a lot easier to write about federal constitutional law because it's attractive to every single law review out there. All those law review editors want to publish things about federal constitutional law. It's relevant everywhere. If you write a groundbreaking piece about the Maryland Constitution, you're probably publishing it in the Maryland Law Review, right? And so there's a lot of reasons why structural bias has meant we focus a lot on federal constitutional law. It's much easier to be an expert. Not that it's particularly easy these days, as things seem to be rapidly changing, but in general, it's been easier. So if you are interested in litigating in a state, not only do you have to figure out what that state constitution looks like, you have to figure out what the state appellate courts have been doing in a constitutional interpretation in their state. And so Virginia, by way of example, is a state that for a long time fell into the lockstep camp. And so I'm going to try to be more specific about what that means, because maybe not everyone in this room has had as much experience litigating these sorts of cases. But what it meant in Virginia is until about 4 years ago, if you brought a provision under one of our Constitution's Declaration of Rights provisions that you heard mentioned preceded the federal Constitution's Bill of Rights, our free speech clause, our cruel and unusual punishment clause, our search and seizure clause, etc., our clauses that resemble what ended up in the United States Constitution, our courts would say, writ large, we don't need to look at the text. We don't need to look at the history of when it was amended. We don't need to look at any unique features of what it means to be a Virginian. We just say samesies. It means the exact same thing as however the federal Constitution has or will functionally interpret that language. And you might laugh now because it seems kind of ridiculous, particularly given our new focus on state constitutional law and what's happening in state courts all around the country. But there was some good reason for this. If you take a step back and think about the incorporation doctrine and the fact that federal courts basically progressively over the course of the 20th century said, state courts, you're kind of getting all this wrong. You're not doing a good job protecting rights in your state, so we're going to remove that from things you should worry about. Now, they did that with respect to the federal Bill of Rights, not with respect to state constitutional provisions, but the message was pretty clear when it came to rights. This is now a federal issue, and states need not apply. I think that's how a lot of state court judges interpreted what was happening. And one unique feature of state constitutional interpretation that hasn't come up yet this morning is the relationship between state courts and state legislatures. We, as state judges, are a lot more accountable. That's one nice way to maybe put it, to the people in our states, to the legislators in our states. Another way to put it is that we can be removed a lot more easily. Our judicial offices can be persuaded much more easily by what's happening in the legislature, by our governors. And so there have been examples over time of where state courts really kind of got out ahead, perhaps, of some judges on state courts were out ahead of where their legislatures, where their people wanted them to be, and so they're removed, or their courts got packed, or things happened to kind of clamp back on those sort of moves of judicial independence in states. So there was a long tradition of states just saying, we'll do what the United States Supreme Court says is the right interpretation of the Federal Bill of Rights. So that was the case in Virginia for a very long time. As Judge Sutton's already given you an overview of some of the reasons why forces are at work, changing some of the ways people are thinking about it. I think one big reason that things have changed is the methods of interpretation that our United States Supreme Court is using to look at constitutional text. And as Judge Sutton mentioned, state courts aren't bound to use those same methods, but a lot of them are at least influenced by, persuaded by the merits of some of those methods. And it becomes pretty hard if you are a textualist judge, if you are a judge who thinks that the public original meaning of text is important, to say, well, I'm not going to look at the fact and consider that in Virginia, the Constitution was rewritten in 1971, and the text is different in some respects now than analogous text in the federal Constitution. It's hard to say that that's your method of interpretation and then ignore those very unique features. So all that to say that in Virginia recently, there has been our real first decision saying that a provision of our Constitution provides greater protection than an analogous provision in the United States Constitution. And it's particularly notable because I think a lot of attention that's been given to state constitutions in the last 5 or 6 years has come from the idea of, okay, well, we've seen arguably a rights restriction at the federal level, and so we're going to go to the states to find more rights. That's it's a crude way of putting it, but I think that's drawn a lot of attention, at least from progressives and those on the left side of the aisle, for why we care about states. But what happened in Virginia shows that really state constitutions can cut either way. You might find more rights regardless of what side of the aisle you're on. So in Virginia, the Vlaming decision, which is V-L-A-M-I-N-G, was an example of where our Supreme Court found that there's greater free exercise protection in Virginia than there is in the federal Constitution. And there's lots of reasons for that. There's already been mentioned this morning that one very compelling reason why a state might assign different meaning to its provisions of a state constitution is different history, different kind of a different mode of being in that state on a particular topic. And the Virginia Supreme Court looked to the long history of the protection of the free exercise of religion in Virginia. You probably can call back. We talk about Thomas Jefferson all the time in Charlottesville, Virginia, where I live.
Into that, yeah.
We're really into TJ. But you might even remember from your grade school days Jefferson's strong views about separation of church and state, free exercise of religion, all these things coming back in Virginia. And so our Supreme Court looked at the long history. We looked at the fact that our text, you don't have to say, you don't have to find textual differences as a state jurist between your provision of a state constitution and the federal Bill of Rights to say that they mean something different. You don't have to, but if the text is different, it's a very compelling reason why you might say this provision should be interpreted differently. And whereas in the First Amendment and the federal Bill of Rights, there's a brief mention of the free exercise of religion, the text that gives rise to that provision. In Virginia, we have paragraphs about the free exercise of religion and how important freedom of religion is in Virginia. All that to say that the Virginia Supreme Court found that it was a teacher who had been fired for refusing to use male pronouns for a transgender boy student in the teacher's classroom, that firing had violated his free exercise rights under the Virginia Constitution, which I think a lot of people would view as a conservative or kind of right-leaning interpretation on a political issue if you extract from what was happening in the case. But at the end of the day, it was very significant because it was the first time that Virginia said, yes, we appreciate in all these prior cases we have said our provisions mean the same thing, but essentially we just mean that at the time it meant the same thing for the right that we were interpreting. But we're no longer making a blanket statement that every time a provision has to be analyzed that it's going to mean the same thing. It might mean something different. At this point, we're acknowledging that the federal interpretation of an analogous right is just sort of the floor, and Virginia has the ability to go further. So that's an example of what's happening not just in Virginia, but I think in a lot of other states that are looking anew at their state provisions and trying to see if we are applying whatever method of interpretation, and that's part of the challenge of doing state constitutional work, is figuring out, well, what are courts saying, what methods are they using, and how are they getting there?
Can I ask how did that land with the General Assembly? I mean, did they, two questions. I mean, that was kind of a controversial topic, number one, but number two, they might have thought, well, you're now going to start independently construing all this and second guessing our legislation. Were they all on board with the decision, or were they?
Well, I mean, there's been no formal legislative changes in response to that particular provision. I'm sure someone could think of a way to do that, but because it was a pure constitutional decision, not evaluating a statute, but just reviewing a school's decision to fire someone. And so as a pause, in Virginia, we had one of only 2 states where our jurists are chosen by our General Assembly, by our legislative body. The vast majority of states, either judges are chosen by direct election or they're chosen by the governor. So either the executive branch is choosing or the people are directly electing. In Virginia, the legislative branch, Virginia and South Carolina, is choosing the judges. And unlike federal judges, as I think most people in this room know, we only have a set term of years. So I have an 8-year term. Our Virginia Supreme Court jurists have a 12-year term. The judge who wrote the decision is coming up for re-election, reappointment functionally by the General Assembly. And historically in Virginia, people have always just been reappointed, reappointed, reappointed. It's hard to even look at the news without seeing something about a state Supreme Court somewhere. We're all paying attention now to elections in Michigan and Pennsylvania and different places for their state Supreme Courts. And I will note, I've gotten to know Judge Friedman because we're both at a program together that the Bolsh Institute down at Duke Law School does, and one of our colleagues on the Utah Supreme Court, and in that program. And what's happening in Utah is another interesting example of the tension between state courts and legislatures, because even though all the Utah Supreme Court justices were appointed by Republican governors, and they were not conservative enough, reportedly. And so Utah has added 2 new justices now to their Supreme Court to go from 5 to 7, and also invented a new 3-judge panel to handle constitutional matters. So take constitutional cases away from the Utah Supreme Court and give them to a special. It's being litigated whether it's constitutional or not.
Are they picking those 3 people?
Yes, they picked those separately from
Not
anyway.
very subtle.
So so there are. I think there's good reasons to look to state courts, but there's also reasons why people have been skeptical, I think, over time of it would be a lot more efficient, let's say, if you can get the win at federal court, where you have people who are there for life who can't be tampered with in the same way by legislatures. So just some of the dynamics. And one other thing I wanted to point out before we certainly want to make sure we hear your questions is how many unique provisions state constitutions can have. So there's the analogous provisions, and that's where you would have to look at whether your state has been lockstepping or whether they're doing their own thing. But then there's a lot of unique provisions in state constitutions. There's unique areas of spheres of influence that are given over to states really everywhere. So that's education. Judge Sutton already mentioned the federal courts have said we're not in the realm of saying there's any right to education in the federal constitution. That's left to states, and there's often very specific provisions when it comes to school funding, but other things as well. There's environmental clauses in certain state constitutions. A lot of those have been in the news in Montana. There's clauses in Hawaii, other places about the right to a fitful kind of environment and what that looks like, and does it have real teeth or not. And then there's also, as Jeff Sutton also kind of previewed here, the realm of elections and how states participate in what ultimately becomes the federal electoral process by drawing the electoral maps. And so there's a lot of litigation happening there. There's been litigation in New York. There's things happening in Virginia. There's things happening, as you read about, in Texas and California, no doubt, where states have this very unique role there. And that also goes to sort of the amendability of state constitutions. It's very easy to amend. So right now in Virginia, we're having a special election in about a week to decide whether to redraw our redistricting maps following kind of what California did with Prop 50 out there. And the Virginia Supreme Court has basically said they're going to wait to decide whether the special election process that the General Assembly has set up in Virginia for this election next week, whether that's constitutional or not, until after they see what happens, because they may all be mooted, right? So if it goes forward in Virginia and less than the majority of people vote to redistrict, then they won't have to worry about it. I suspect that's why they've decided to kind of wait. It would have been very difficult to get the briefing done, everything done in a timely way. But so those are some of the things happening on the ground. And one thing I did want to mention while I had the opportunity is it's hard to keep track of what's happening in all these states everywhere. But right here, since we're at NYU, it's worth mentioning that the Brennan Center nearby, and also kind of affiliated with the law school here, does an incredible job of putting out a newsletter called the State Court Report, which I can't recommend to you enough, as collecting what's happening in states everywhere. Every week I get this just incredible newsletter that tells me, like I was reading this morning, in Pennsylvania, speaking of kind of states relying on their traditions of what's happened in that state as a reason why a provision might be interpreted differently, Pennsylvania just last week found that their cruel punishment clause of their constitution, so prohibiting the cruel punishment in their state, they relied on sort of a long history of the Quaker roots in Pennsylvania as a reason to find that if someone was convicted of felony murder, so whether you participated and actually were responsible for pulling the trigger, whether you were just in the car as a getaway driver, if you have any responsibility in the felony murder kind of conviction, you can't get a life sentence without the possibility of parole anymore in Pennsylvania. That violates their Constitution's cruel punishment clause. There's no other state that I'm aware of has gone that far with what cruel punishment means in their state under their state constitution. But I just learned about that this morning by reviewing the state court report's very helpful overview of what's happening in states everywhere. So I just can't recommend it to you enough if you're interested in these topics.
Well, I've got a few questions for my colleagues, but maybe now is a good time to see if folks here have some questions based on things we've said or things you were hoping we would address. And yeah, go ahead in the back.
Hi, thank you all very much for coming today. This is much better. I had a question based off of what Judge Lorish just said a little bit about a concern of what you might call fair weather federalism, that there's a lot of really good neutral reasons why we should turn to state courts for consideration of rights or a lot of important salient political issues that go up in the courts, but that one motivation for doing that might just be who is in power in the federal government, and we see a lot of litigators and litigants go into the state courts just because they think they're going to lose at the federal level. Based on your experience on the state bench, what sort of advice, what tools do you think that the state courts have to make sure that these issues just don't become another political battleground and really do maintain the sort of neutral principles of it's good for state courts to decide these issues because there are local conditions, because state court constitutions might actually say different things about them, as opposed to just having, again, the fair weather federalism issue come up.
Which one wants to go? You want to go first?
I can comment briefly, sure. I think it's my hope that in another 5 years that concern won't feel so salient because state courts will have been much more regularly doing their job to be interpreting provisions of their state constitutions. So I think Judge Sutton has written about this in one of his books.
Call me Jeff,
Jeff,
unless
okay.
you're disagreeing with me.
Well, you haven't heard what I'm going to say next. But that, if a state court's doing its job correctly, you would fairly interpret a provision of a constitution in a way that might say, hey, our state constitution actually sets the floor lower than what the federal constitution might require. For example, Virginia actually doesn't have a search and seizure provision in our constitution. We don't have something that says it's unconstitutional. You can't do it. What does the federal constitution say? Unconstitutional search and seizure. That doesn't appear. We just have a provision about general warrants. So if I was actually faced with a Fourth Amendment case brought under the Virginia Constitution, I think it would be incumbent upon me to say, we don't actually have that limitation in Virginia. In Virginia, you could do a warrantless search as long as it wasn't a general warrant, but that would be fine. However, and to fairly say that's what our Constitution requires or allows. However, in this circumstance, the federal Constitution trumps us and requires more under the Federal Bill of Rights. And not to kind of gloss over those two steps. I think they're important. Here's what actually is true in Virginia, and then here's what happens to be true federally. And then I think that gives more credence to the fact if later a judge also says, and also in this other area, our state requires more than the federal Constitution. And so if we get into the habit, if state judges regularly get into the habit of interpreting the documents before them, I think it takes away some of the political valence. Because if you're doing what you're supposed to be doing, and you're doing it for a long enough period of time, then the politics falls out and you're just interpreting text, which is what we do all day long, whether it be statutory or constitutional. So that's my hope, although right now I think it's hard to disaggregate the renewed attention with some of the motivations of litigants. And the other thing, speaking of litigants, I always say when I have the opportunity is, I can't address a single constitutional question unless someone has put it before me. So, and it takes a long time to get before an appellate court, for those of you who are litigators, So we're just now starting to see some cases brought in Virginia that are really challenging things under state constitutional provisions, 5 years after the Lamming decision, because it just takes such a long time to get going. So it's a long time horizon, but my hope is with more regularity, the political falls out. So that's my view, at least.
So, first of all, I think that's what litigants do every time. They're going to pick the forum that they think is going to work for them. So, as Lisa said, we don't control that. For me, I think one of the things that I think about is I think the story that Jeff talked about the development of state constitutional law as being Brennan talking to the liberals, bemoaning the changes in the U.S. Supreme Court is exactly the right history. But over time, it's really complexified with decisions like the Vlaming decision. And if I might say, I would say this more freely with Jeff not in the room, but Jeff's background being from perhaps one side and being a national contributor to the idea of state constitutional law, I think has really freed that from the restraints of its origins. I think the origin story, by the way, of originalism is a really similar story from the other way. It starts as me thinking that this is and maybe Judge Bork or maybe not, thinking that this is going to be a way to get outcomes they want. And then over time, people built an intellectual scaffolding underneath it so that it could be used by anybody. It's really much more a neutral idea than having the political valence. I'm happy to have that discussion too, but I think that happens in the history of ideas as they show up as a weapon for one side, and then a scaffolding gets built underneath them that makes it possible to use for both sides.
Yeah.
I don't know if that...
I have a couple of thoughts, if I could add something as well. It's such a great question. It gets to the heart of quite a few things. So one is just to step back a little on federalism, and it's a very American idea. It's something we innovated. And one feature of federalism has nothing to do with courts. It's that you can have Congress doing one thing and a state legislature doing another. And that, of course, is fair weather. That is very much, the people of Ohio want to do this. It's a little different from the national government. A way to capture that policy point is we have 51 different tax systems. No one thinks we should have one tax system. I mean, it's annoying on April 15th to do all these returns, but every single one is different. Our policies of how to raise revenue and spend it, each is its own story, and there's nothing wrong with that. And there's nothing wrong with deciding I want to be in a state that does more of this or more of something else. I think the second thing about it being a little too results-driven of, gee, you're just going to state court invoking even this identically worded provision just to get a second bite is like, yes, that's America. Thank God that a criminal defendant in a local or state criminal prosecution has 2 shots of staying out of jail. I mean, we are quite a libertarian country in that respect. And so giving citizens 2 chances, even a fair weather chance, is not a bad thing. And I would say, even though there's been so much action in the last decade or so, I still think we're not even close to Americans really understanding the second shot when it comes to state constitutions, as opposed to the second shot when it comes to legislation. And a very good example of this is this case Terry versus Ohio, where stop and frisk is something the Fourth Amendment of the U.S. Constitution permits. It's astonishing to me that not a single state court has even considered whether stop and frisk makes sense in Baltimore, Minneapolis, Ferguson. How are we not even... That just proves we have, in my view, complete civic ignorance of this second shot. So we're so far away from, just pure fair weather federalism and kind of cynical uses of courts. We don't even know about the second shot. As shown by the Terry example, they're not even, using it. Now that said, what...
I read a great article about that in the Virginia Law Review recently.
Yes, that is a great law review article, and I'm sorry that I've burdened you with this point before, because that's why you're mocking me with this. The article is by my son, of which I'm very proud, and I was going to show the restraint of not mentioning it. But anyway, it does show my commitment to state constitutional law. I'm not only writing books and articles, giving talks, but my wife and I are bringing people into the world and making them write about state constitutions. So you should definitely have your conscience saying, maybe I could do a little more here. But I want to go back to a really serious point of this question of this politics of the courts. This is a very big problem right now. And I'll give the, I don't mean this because this is not how I think, but I want to acknowledge the possibility that others think this way, that cynicism about the U.S. Supreme Court and cynicism about some state courts. If one's cynical about the U.S. Supreme Court and thinking that politics and worldviews are entering the mix too much, okay, you're allowed to think that. That's not what I think. I think we federal judges are doing the best we can, but let's say you have that thought. Well, surely you're allowed to use politics at your state court. I mean, you're not forced to fight with one hand tied behind your back. I was very disturbed by the Wisconsin State Supreme Court election a year ago. This past year was a little more tamer because I found myself wondering, what does it mean to be a judge? And it really looked like on issues like abortion, gerrymandering, and unions, they were treating their judges like representatives on these topics. Now, that's the bad news. The good news is, I think once you get beyond those topics, they're doing what judges do. I think this was what Lisa was saying, and that's good. And I think at the U.S. Supreme Court, there's real pressure on them in issues like gerrymandering, abortion. But typical cases, I think they're doing what they do. And I'll make one last point to echo Dan's idea that federalism in general, state court federalism, is not remotely right, left, originalist, living constitutionalist. It is for everyone. And I can illustrate this by a wonderful story for me, is a fellow who used to do IJA stuff. His name's Hans Lindy, and there's no reason you would know who he was. He passed a few years ago, but he was this epic professor at the University of Oregon Law School, and he was on the Oregon Supreme Court for 15 years. And I would say he, more than Brennan, really brought to life this idea of second shots and using state constitutions. He's really a significant figure that we've just kind of lost track of. And I had the good fortune when he was just a couple of years from dying, but very with it, to meet him. He's about 92 at the time, and I get to meet him, and I'm just so excited to see him. And I say, Hans, I just don't want to waste this precious opportunity. I just have to ask you a question I've wondered about for so long. I'm a conservative. It's understandable conservatives, at least in this era, think federalism's a good idea. But I said, Hans, you're a progressive. Like you clerked for Justice Douglas, and you're as progressive as they come. Did you not get the memo? Why were you doing all this state court federalism stuff? And he just says, Jeff, it's purely autobiographical. I was born in 1924, pre-Nazi Germany, family Jewish. Hitler comes to power. His father was a lawyer. The father doesn't like what he's seeing, sends mom and 2 boys to Copenhagen, Denmark. Father stays and says, that maybe things are going to get better here. They don't get better. Father goes to Copenhagen and eventually says enough is enough. And in 1939, think of how lucky they were, they go to Portland, Oregon. I don't know why Portland, presumably family, some reason. And then Hans said, I had 2 missions in life. Copenhagen, Denmark was a sanctuary for us. So I wanted to spend the rest of my life making Portland, Oregon, and Oregon just like Denmark and Copenhagen. And I knew what centralized government looked like if you weren't careful. And so I wanted to do everything I could to avoid the United States running into the problems Germany ran into. That's a progressive. This centralization is not an issue that is Republican, Democrat, et cetera. The risks go both directions, and it's quite a bipartisan issue, which should really warm our hearts. It's hard to find something these days that applies to all of us, no matter our worldview, and I think it's kind of showing up in the state courts with each different story. Great question. Let's have another one just like it. Yeah.
So I'm a 1L that has not taken common law.
Oh, no, that's perfect. You're a blank slate. Don't take federal con law. Just listen to us. It'll ruin you.
So one of the things I think I've gathered from the talk is that the federal Constitution, and as interpreted by the Supreme Court, is kind of setting the minimum or the floor for then what states can build on top of. And in like the First Amendment context, at least, it seems like that would be it's simple to understand which way that floor is pointing. But then maybe in like the taking clause context, as in Kelo, it might be a little bit more difficult to figure out, right? Like, is it setting kind of the right for the state in order of when they can and cannot take property, or is it setting the right of the property owner about when they can retain or have to give up their property? So my question is how did state courts kind of go about figuring out which way that floor is pointing? Is there room for disagreement on that front? And I don't know, how would you address that if presented with that kind of question?
Go ahead.
Well, so one area that makes me think about is the shopping mall cases, and whether the private property rights of the owners of the mall, they say, I want to be able to restrict who could engage in political activity in my shopping mall. Those are my private property rights, and so those are important rights to me. Meanwhile, the people who want to leaflet say, well, there's no downtown anymore. The only place I could effectively leaflet and see people and talk to them is at the shopping mall. So I have a First Amendment right. And some of the courts have said, well, look, there's a state action doctrine as part of the First Amendment, and this is not a state actor. So the answer is this isn't an infringement on anybody's free speech, and so the property owner wins. Other state constitutions we don't have a case like this, so I'm only hypothesizing, but our First Amendment analog provision, Article 40, does not have a state action requirement, although our Supreme Court hasn't noticed that yet, but someday they will. And there are states which have found the speech right is more protective. In the Pruneyard case in the Supreme Court says, in the dissenters all say, well, we're deciding it this way, but the states can do what they need to do. So sometimes it's hard to figure out. I'm not sure I answered the question now that I think about the question.
No. You gave him a lot of credit with that for a 1 hour. I love it that you thought he was asking the hardest question imaginable. That proves our respect for NYU. But I'm going to answer the question you didn't ask, but might be on some other people's minds, of just how these two things work, the floor point. And the floor is actually a terrible metaphor. So we got to ban that metaphor. And if you like metaphors, we'll use elevator banks, because that one is better. If you're in the federal elevator bank, you can go up as high as you want, you can go down as high as. It's what the U.S. Supreme Court and the federal courts have done. So when it comes to takings, that bank it's only got to the second floor. They're not doing much protection on the public use takings clause. They're letting the states essentially do what they want. When you get to take your second shot, you now move to the state elevator bank, and the state courts can go up as high as they want. They actually, believe it or not, can go even lower. All they have to do as a matter of honoring the supremacy clause is, with the federal claim, they obviously got to respect Kelo. But they can take their elevator rank down to zero. They could just say, we have no protection. We're just going to write it out of the Constitution. The state high court, they're in charge. But the people can respond by getting new judges or amending the Constitution. So usually it's just as simple as, which elevator bank are you in? You can go up as high, and you can go below the federal floor if you want. And I think what Dan was getting to was, every now and then, if you go way up a state elevator bank, you might implicate a federal guarantee. So the example of that would be like state establishment clauses. Sometimes under these Blaine amendments, they've made it very hard to use state money for, say, vouchers. Well, that might implicate federal free exercise rights, right? So that's what I think Dan was trying to show, is they sometimes cross over. But usually you don't have to worry about it, and usually it's a free hand. You can, if you're a state lawyer, you want that thing to be as low as possible, and if you're representing a criminal defendant, you want to go as high as possible and see what you can do to persuade the state court. You don't have to tell us which question you really asked. I think you asked his question because I think you're pretty smart. All right, other questions? Okay, over here, yeah.
Curious for your take in looking at your elevator analogy that you just did.
Well, escalator, yeah.
The represent London public sector unions in the New York area. We litigated cases during COVID about vaccine requirements. Part of what seemed to be troubling was that there was an argument that if all you say is religious exemption, the courts can't look into the bona fides of that, which personally makes little sense. But my question for the panel is, do you see the interstate constitutions being able to be used in order to say that under federal law, it may be that you can't look into the bona fides, but our state is going to allow it?
Definitely. So that's a little bit like Dan's idea with Wren of you under federal law, you never ask the police officer why you really stopped them. And looking at the bona fides would be looking like, why did you really do this? And so free exercise in COVID, there was a lot of free exercise COVID litigation, and that's one where they're really separate. You're just in separate banks, and if you can convince the state court to go higher, good for you. Now, the federal courts, ultimately, it took a while, but the federal courts ultimately granted relief in quite a few free exercise cases. I mean, they've been, if you ask me, pushing the envelope on neutrality. They really have insisted on complete neutrality when a free exercise right is implicated.
I'd say free exercise is a real growth industry. So if you're looking to find a lane to bring a lot of litigation in, I was also just reading recently, we think about the question of abortion, and we've typically thought about it in the bucket of substantive due process, right, in the federal rights context. And under Dobbs, we know that right is not part of the bank of sort of substantive due process rights under the federal Constitution. And as you probably know, there have been state courts looking at, well, do our kind of express or implicit due process rights protect abortion under different state constitutions? Another example of a different elevator bank or escalator bank where, some states have said, yes, even though our language is exactly the same as the federal Constitution, we think that there is a protection to abortion under our state constitution. But there's also people bringing really interesting free exercise challenges, saying under my religion requires me to evaluate whether I should have an abortion in certain contexts. And there are, at least at the trial level, I'm not sure anything has gotten to the appellate court yet, but courts saying, yes, we think that the free exercise protections for your religion, without necessarily getting into the bona fides question, but that does require access to abortion and would make a state statute limiting the same unconstitutional in certain circumstances. So all that to say, it's another example of where a lot of things are happening, I think, at the state court level.
So can I just talk about, as long as we're on Dobbs, I don't think it responds exactly to that story. In Maryland, we amended our Constitution to enshrine the right to reproductive choice, is the way it's framed. I think, though, one of the most interesting things about our new Article 48 is it says, as part of our right to equality and liberty, you have the right to reproductive freedom or reproductive choice. What I think is especially fun is there was no prior equality guarantee explicitly in the Maryland Constitution. So we now, I think, and we now have a textual equality guarantee where we never did because of the way Article 28 was drafted. It recognizes this background right to liberty and equality, which I just think is fascinating. Like, Was somebody thinking about this?
Well, I mean, now we've talked Dobbs. Now's alienation hour, but we're it's obviously a controversial topic. But if we can kind of just try to step back and put to the side just for a second our strong personal views about this issue, it's really striking, the post-Dobbs story. I mean, here we are. We're not yet 4 years since then, but you used the Maryland example. Ohio is a center-right state. Our neighbor Michigan is a center-left state. They both amended their constitutions within a year or so of Dobbs. And the striking feature of that is that the state constitutional amendments in both states give more reproductive freedom rights than Roe did. I mean, so, looking back on the Roe era, again, I'm trying not to say pro or con. I'm just doing my best to neutrally describe things. When you had Roe, the attention was focused in one place. It was just focused on Roe and were there going to be exceptions, but those exceptions were going to be created by the U.S. Supreme Court. And the story of Roe from 73 to Dobbs was not growth. It was cutting back each time. In fact, that almost happened in Dobbs, right? I mean, that was the Roberts approach, to cut back more but not overrule. But to me, the politically interesting point is all of our political energy about this super salient topic was focused on the U.S. Supreme Court. And the minute it left the stage, again, for better or worse, I know people have strong feelings about this, the tension, putting the accountability spotlight on the states is just astonishing, its impact. And, I don't think we're going to know how this played out for probably another 8 years, or, I think it'll take roughly 10 years after Dobbs to kind of figure out how this all landed. But it's quite striking. Again, I realize people have strong views in probably both directions, but it really is amazing what happens when the accountability spotlight is shared through 50 states and not just one institution in the national government. Well, if that wasn't controversial enough, let's go to death penalty, which is just one other one to illustrate how counterintuitive things can be. And this one, because I'm known as a conservative, I'll point out this is an area where I have progressive leanings. I'm not a fan of the death penalty, so it's interested me for a long time. Listen to this story that most people do not appreciate. Numbers of executions in this country capped at about 200 a year in the 1930s. So from the founding to the 1930s, it just goes up. The graph line's just up. It caps at roughly, and I'm only talking executions. I'm not talking about capital sentences. So it's about 200 executions in the 1930s. It then goes, the graph just turns and goes straight down to I think it's 67, when you have the last execution from the 1930s. You have 5 years between 1967 and 1972 with 0 executions in this country. At the same time, democracies around the world that share our values and history, traditions, were eliminating the death penalty. European countries, Australia. And so the U.S. Supreme Court, again, they're not initiating these cases. We passively take this stuff. They get this case in 1972 in Friedman, and they're asked to abolish capital punishment across the country. And, if I were a Supreme Court justice, I must admit in 1972, I would have thought, what could go wrong? I mean, we're not using it. The confidence in it has dissipated. Other countries that share our values are not using it. And so a 5-4 majority of the court says, well, 2 of them saying you can never do it, and the other 3 saying it's too arbitrary who lives and who dies. I don't know if this is just an American quality or a death penalty issue. I don't really know the answer, but Americans don't like being told what they can't do. Because even though no one was using it, when the U.S. Supreme Court says they can't, they suddenly respond with alacrity and say, okay, well, we're going to update our systems. Guess what happens? Starting in 77, the graph now goes straight back up to, I think it caps at 98 a year in 99 or 2000. A lot of those executions would not have happened but for Friedman. I'm not saying some states would not have started executing people again. What I am saying is the backlash led to more than would have happened otherwise. What's happened since 99? The graph has been going back down. Unfortunately, this year it has an uptick. But if you stop at last year, it's going down to about an average of 25 a year. Probably 5 to 10 states actually doing it. A bunch of other states are kind of symbolic but never use it. And more than half the states have gotten rid of it. That story of going down has had nothing to do with the federal courts, or very little to do with the federal courts. It's a local story. So I'm not trying to say localism's always right. I'm just showing how complicated it is. And by the way, the state story of doing less is not just state constitutions and state judges. It's governors, it's legislators, sometimes constitutional amendments. In other words, there's a lot of tools that can be used locally, and it's not just fair weather federalism through state courts. It can be, again, governors, legislatures, and constitutional amendments.
Maryland has two interesting points on that. You mentioned Obergefell earlier. We did that legislatively before Obergefell when I was working for the legislature, and abolished the death penalty legislatively. And I think oftentimes our General Assembly is way ahead
Of the courts.
of the courts.
Not a terrible thing.
Popular.
I mean, yeah, it's not.
How it's supposed
Can
to
I
be.
ask you, Lisa mentioned that this Virginia, South Carolina thing of the General Assembly actually picking the judges, and my understanding is you're actually there during the election. I mean, you're in the General Assembly. Isn't that amazing? and is there a competing candidate? Like, is a colleague?
No, I mean, realistically, at least in the modern era, the decision is sort of made by the courts of justice and Senate justice committees on the House and the Senate side. Sort of by the time you get up for the actual election, the cake is baked at this point. And so it's just kind of pro forma, the election's happening, and you're not really being asked any questions of real substance. But I think in a different era, it was different.
And what's your selection system?
We have what they call the Missouri Plan, the state, but it's all created. It's not in our Constitution. It's created by executive order, and the governor limits himself to appointing him or herself, but it's from a list approved by nominating commissions, and then we are appointed by the governor, voted by with the advice and consent of the Senate and of the state Senate, and then we run in retention elections for 10-year terms. By the way, I'm up for retention this year. If any of you vote in Maryland, I'd appreciate a yes. That's my campaign speech.
Well, you're really being aggressive. You're trying to get votes in New York. That's amazing.
Let me just be clear.
You're going to win. You're going to win. You're going to win.
entire,
You're going to win for sure.
Campaign right now.
Well, one other thing I might just point out on selection systems, I think a decade or so ago, if you talked about selection for judges, you might have had the reaction I used to have, that the federal system was a pretty good one for creating independent courts and independent judges, because it's president nomination, Senate confirmation. Once you're through that political drama, it's life tenure, and the further away you are from those events, the more independent you could be. The question is whether that's still true, and I'm not going to take a definitive stand on that, but I can certainly imagine an argument that is the federal court selection system is no less political than the Wisconsin one, or the Virginia, South Carolina model, or a retention model, and what to do about that. I saw a hand go up, so yes.
Two comments. One, I practice some in New Jersey, and New Jersey has the weirdest system for choosing intermediate appellate judges. The Chief Justice chooses from the trial judges who sits on the appellate court. That's unique to New Jersey. On the point of independence, the federal system's pretty good, but based on an incident I actually know, the notion of promotion creates a problem of federal independence. If you're a district judge and you want to become a circuit judge, if you're a circuit judge and you want to become a Supreme Court justice, the fact that you now need to think about what are politicians going to say in the promotion confirmation process is a limitation on judicial independence that I've not seen argued or described much in the literature, but I know of an instance of a federal district judge who ruled against the United States. The Attorney General called him up and said, people had talked about you for your circuit, you're not going. And if that story gets out, it seems to me it necessarily has a chilling effect. And I don't know how to deal with that, because I think having appellate judges who have trial experience is a good thing. But I think the potential for promotion leaves the system open to political influence. I wonder what your thoughts are.
Well, good for that judge, right? That judge was independent after all, so it's always nice that it landed there. So that's the audition problem, and I think you're right to worry about that. I mean, it's human. There's a little bit of human nature, and I think we should probably acknowledge that most people that become state or federal judges, yes, every now and then someone's just tapped from behind and had no inkling they'd ever be a judge, never tried to be a judge, and everyone had been watching what a great person they are, and lo and behold, they become a judge. But the reality is probably that most state and federal judges had some ambition, and this was something maybe they wanted to do. And so I think you're right to say that I don't know why, having been a Court of Appeals judge for 23 years, I don't know why a trial judge would want to be a Court of Appeals judge, I got to tell you. I mean, we don't always have to show up for work. I guess that's a nice thing about being an appellate judge, but I never get to do anything by myself. So I'm either at home with my wife where I don't have any control, or I'm with my colleagues. I mean, it's just, there's just misery. I never get to do what I want. So, maybe one shouldn't think that way, but I think you're probably right that many trial judges would like to be Court of Appeals judges, and there are more than a few Court of Appeals judges that have looked in the mirror and seen, staring back at them, a U.S. Supreme Court justice. And so that audition thing, I do think one thing for the Court of Appeals judges, it would really be quite disappointing if they were really making decisions on this ground, because it's so delusional. I mean, it really is a lightning strike situation, and it doesn't mean people don't think it's within the realm of possibility and they'd like to improve their odds. But it's, in my view, it's quite crackpot, because what ends up happening is, this is true misery, because what happens is you bend your decisions to improve your odds. Now, if you don't get it, the most likely thing, you've lost the greatest thing about being a judge, where your client is the rule of law and you're calling it straight, and you can have some pride over a career of trying to call it straight. And then the other possibility is you actually get it. Lightning does strike. And now you got to figure out whether you let the world know you're an imposter. I mean, so now you're either stuck with the pretending thing, which is awful. Now you're a Supreme Court justice and you're not even doing what you really believe because you want to be consistent with your auditions, or you're perceived as committing treason because you now shift to what you truly believed all along, and people think you were playing games. So it ends up terribly from my perspective, and I think the same thing would be true for the trial judge. You're losing the greatest. I mean, this is such a privilege to have this job where the rule of law is your client. You're trusted to be a public servant and try to figure out what's best for the case and the law. And to have that ruined by ambition really would seem unfortunate. But human beings are human beings, so I think you're right to worry about it.
So I went out to dinner with a group of judges, a Maryland group of appellate judges and a group of North Carolina appellate judges. And I was struck by the very different personality types. We Maryland judges don't really run for election, and we are nerdy people who live in libraries. And the North Carolinians are politicians who shake hands and kiss babies. And it was the system of selection and retention of appellate judges is not just a political science question of which is the best. It created, or somehow we all belong to type. And I looked at them and was like, I would never be an appeals court judge if I was in North Carolina. And I'm sure they looked at us and were like, what's wrong with these nerds, right? So I think it's not just a political question, a political science question. It's how is your judiciary going to function, and what kind of people do we attract to it? And ours has decided on this system. Of course, ours is because it happened over time and in different ways. Our district court, our limited jurisdiction trial court has one appointment and retention system. Our circuit court, which is our general trial court of general jurisdiction, has semi-partisan elections. And the appellate courts are a completely third set. So we're all a big mess.
Yeah.
I'll just briefly add, I think the question that you're asking really gets at the question of what does it mean to have character as a judge? And I'll say it's a lot of people, before I became a judge, would talk about robitis, right? Like someone puts the robe on and they become this different person. One, you never see them anymore. You can't get access. They don't hang out at the bar events anymore in your area, or they are kind of, they seem like different and they're not what they used to be. And I also heard a lot of people, as soon as I managed to luck into this position, oh, how are you going to deal with the loneliness? How are you going to deal with the isolation? All these things that I thought about on the front end, but you can't really fully think about. And so there's all these aspects of what happens when someone becomes a judge. How do they manage all of that? And if you're more like me than maybe the model of a person who became a judge before, and by that I just mean I didn't have a roommate who was a senator. I had to kind of put myself out there and really, I was a striver. There's no way around it. I had to work and claw and try to get people to notice me, to put me on the bench in the first place. If that's your story coming onto the bench, it can be hard to figure out then, yeah, how do you shut that down? I don't want to write opinions for Twitter. I don't want to write opinions for a future promotion. I don't want to be a state judge who's trying to become a federal judge later, which used to be a pretty common path.
That's a demotion.
Yeah. But I think that was really common for a long time. State judges weren't thinking about states. They were thinking about that next position. And so all to say, I don't have an answer other than I think it's a pervasive thing that judges have to figure out how to have the character of the office that they're inhabiting and to do the task in front of them without kind of contemplating what's next and without writing for Twitter and without writing for whatever. And I think it's a task we all share. And it's a burden. So.
Character's a great way to end. So thanks to both of you, and thanks for listening to us.